Welcome and good evening, everyone. I'm sure today's topic is an interesting conversation for every household. We have invited you all to the INCOP webinar where we will be discussing about the succession strategies for safeguarding wealth across generations. To give you a quick intro about us, that is, we at INCOP are an Ascentium-backed company. Ascentium is present over around 22 strategic markets. We have around 20,000 plus clients across the APAC region, and our proposition is to provide business services to larger SME pools operating in the Asia Pacific region. We do specialize in providing family offices and succession planning services across the Asia Pacific region, apart from our regular tax and advisory work. To introduce myself, I'm a chartered accountant with 15 years of an experience in taxation and advisory. I lead the family office and direct tax advisory at INCOP. I'll be your moderator and host for today's discussion. Joining us in our panel today, we have our co-founder, Samir Sanghvi, Legacy Planning and Tax Strategy Advisor at INCOP India. Samir is also a chartered accountant with around more than 20. Samir's expertise lies in tax structuring, legacy planning, transaction advisory, services across diverse sectors. He has business to grow with clarity and control. Welcome, Samir.
Thank you, Megha.
So joining Samir is our guest speaker, Tanmay, partner and head of private client at Trilegal, with over 15 years of experience. He specializes in estate planning, trust, family governance disputes, and cross-border advisory. His work mainly includes structuring of domestic and offshore trust, family offices, pre-IPO trust structures, advising on complex family and asset matters. Welcome, Tanmay.
Thank you so much, Megha. Good afternoon to everyone.
Yeah, so to begin with, now talking about succession, we have been seeing through our history, without thoughtful planning, family legacies always land up in court battles. Right from the inheritance conflict in the Mahabharata to the modern day dispute among the India's most prominent and wealthiest family, the struggle over succession has remained a constant challenge across the generation. Now, today, more than 78% of the civil cases which are pending in Indian courts are related to inheritance and succession planning. With this, we begin our today's session, where we will provide an overview of key succession planning instruments such as wills, trust, power of attorney, and many others, along with the practical case studies. We request our participants to please feel free to use the chat box for any questions which arises during the session. And we will try and answer them in our Q&A session, which is at the end. Yeah, so beginning with you, Samir, can you make us understand whether still the traditional approach to succession planning is still relevant in the today's modern India family setup? Or are family rethinking the legacy and control in a whole new way? Can you have your insights on it?
Yeah, thank you, Megha, for warm introduction and good evening all. Megha, you rightly pointed out how the inheritance in every layman's story is impacting us. Here to answer, there are two main reasons which we should not forget why the disputes are arising. The first underlying problem is that people don't even consider planning their succession at the right time. Even the most prominent businessmen of India left without making a will, causing disputes between two brothers, and rest of the dispute is the history. And if they plan, The problem is they don't plan it well. In another Indian family, which is prominent family, two wills were made, and now apparently the validity of the wills is a question. One person is following the one particular will, and other sibling is following the older one, and both are claiming that to be right. So wealth is lost, but relationships are degraded. This is what is the outcome of these family disputes. If we look at the India statistics, we can find that Fortune India 2021 parameter says that wealth creation generation is lost to 70% of their wealth when it moves to second generation, and when it transits to the third generation, it is further 90% of the wealth is eroded. This underscores the need for the robust succession planning to preserve the wealth for next generation. On a business front, on a right hand side, the statistics of the family owned businesses are also worrisome. Today, over 75% of the India's GDP is contributed by these FOBs, and this number may surpass 80-85% by 2047. Further, 80% of the Indian businesses are family owned, but only 21% have formal succession plan. To conclude, this disparity in the ratio is what in turn exposes businesses to leadership voids and fragmentation of the wealth and businesses. The,
Thanks, Amir.
the emerging trend, if we look at, we should appreciate that COVID has left an embarking effect on the people, increasing the awareness and opting of succession planning. The number has doubled to 34% in 2023 survey. Another important point, the leadership role is taken over to the extent of 40% by the woman, and 55% women are in the management role. So gender equality ratio needs to be respected while deciding on the family succession. HNIs and UHNIs are expected to grow by 50% in next 5 years, and asset under management under the family offices is expected to jump from 30 billion USD to 5 trillion USD in 2028. And 63% of the HNIs believe that their wealth is going to grow at 10% year on year in next 5 years. So overall, India is transitioning towards a nuclear modern family structure influenced by the Western lifestyle, open-mindedness fostered by the education, globalization, and this shifts is requires a thoughtful family succession to preserve our traditional family values and culture, else 80% wealth is at stake. So Mega, we need to have not only the good but sustainable succession planning.
Yeah, thanks, Amir. What I understand from what you said is that number of family offices continues to grow in India, and how they contribute to 70% of the India's GDP. Also increasing female participation in the corporate world. Also the ever rising global mobility, increase in the ultra HNIs and HNIs in India. I believe, and so do you, that a thoughtful succession planning is required to avoid erosion of wealth over the generations.
True.
Yeah. So, knowing this, I would like to call Tanmay. Tanmay, could you please elaborate on how an in-estate succession, that is a situation where a person dies without leaving any inheritance plan, and how can it affect the family legacy or business? Tanmay, over to you.
Sure. Thank you, Megha, and thank you for this insight, and the numbers and the statistics are, of course, startling in nature. Um, Despite all of this, I think one thing that which is inane to all human beings is their struggle with this idea of mortality. No one really wants to confront this issue. Everyone likes to procrastinate on matters regarding mortality. which is completely, it's sort of directly linked to how you deal with your estate. Everyone has been sort of putting it off for a long period of time. When COVID happened, I think it really sort of brought this issue to the fore. People recognized that, this is not something we can leave in abeyance. And yes, there was an uptick in people starting to talk about this topic beyond the four corners of their houses. They started approaching individuals to discuss what they should do about their estate. Unfortunately, this is not the case with everyone, and that can lead to a situation where an individual has not executed a valid will. India recognizes two types of succession: testamentary succession, where you've executed a valid will, and that will is what sort of determines how your estate will be dealt with. And the second and the more dangerous, what we call as the curse of intestacy, is called interstate succession. Now, interstate succession, the way it works is it is determined by your personal law in terms of what religion you follow, and the beneficiaries of your estate already predetermined. It may not necessarily link up and sync up with what you had in mind for your assets. And that could sort of result, in bitterness amongst the family, not enough clarity in terms of business continuity. There can also be assets which are distributed in a manner which make them harder to pass on from one generation to another. Now, given that's the case, it really impacts how you would want to define your legacy for the family. So one critical thing that individuals and family owners and business owners should be mindful of is to at least have a very comprehensive document such as a will executed in a manner which is, of course, recognized as valid under Indian law, to avoid this curse of intestacy. Now, with intestacy, it can also result in family disputes, and finally, there being a lot of acrimonious relationships. To avoid all of that, it's critical to have, a discussion with your advisors and put together this document. Of course, the laws differ basis personal religion, and it's important to recognize if there is a situation of interstate succession, who are your class one legal heirs who will benefit from this. Now, to avoid any of this situation, it's important that we create a framework which ensures that there is no asset fragmentation amongst legal heirs. There are no disputes amongst family members over assets. At the time of demise, there's a lot of emotional strain already. But if you add the situation of there not being a will or a invalid will or multiple wills, you add more financial strain on the family. So it's critical that families take cognizance of this and address this in a more sort of substantial and structured way. And there are ways to do it. There is a succession toolkit available to individuals today where a will is not necessarily the only tool they have available to them.
Yeah, sure, Tanmay. Based on what you said, it is very clear that succession planning maybe right now in the form of will should be there. And if it is not planned, then a law-based planning will take place into consideration. And it may also get into a potential dispute among the family members and also may take years to settle. Yeah. So moving on, Samir, can you also help us understand, why succession planning is also important from a business to run successfully for smoothly and when there is a change in leadership or ownership?
Right. Good question. Good business succession plan preserves the long-standing traditional values of the organization and culture of the business with the least chances or remote chances of the conflicts. It ensures the long-term business continuity, bridging strategically a leadership void. It also helps in talent management in such a fashion that operations and responsibilities, roles and responsibilities are clearly defined. Operational control remains in the hands of the family so that the brand reputation can be retained. And the most importantly, the confidence and the faith of the investors and the stakeholders continues when the family is united and the family values traditional culture is written. These are my takes on this.
Yeah, so based on what you said, Samir, it highlights that how important it is necessary to even prepare a business for succession, from a long-term perspective. And it reminded me of something that I had read, that great empires don't fall because of the lost wealth, but because of the lost leadership. Succession is a destiny, but without the courage to plan for tomorrow, even the greatest legacy fades into memory.
True.
Yeah, so it is better to plan now. With this, Tanmay, can you please help us understand what are the legal tools which are available in India for succession planning?
Sure. And I think I would echo what you've said. India has enough and more cases and examples of some of the largest family businesses when we were young, which we were recognizable brands, but today some of them have faded away. The curse of the three generational rule has impacted them. If some of them had considered, this issue with a bit more thought in terms of what are the tools available to me that I could sort of, work with to ensure that there is longevity on a multi-generational basis, they could still have been titans of the industry today. We are seeing some of the largest family businesses, of course, grab the reins of this and implement some of the tools that I'll be discussing today. The one that I already mentioned, of course, is a robust will. Apart from just having wills in place, one can also consider having power of attorney and nominations, private trusts, also the use of family settlement agreements to sort of mitigate disputes. We are also seeing the advent now of something called Advanced Medical Directive, AMDs. It's still early days. I would want to sort of dive a little deeper into these various tools available because it's important to understand what is possible, what are the limitations, what should one look out for when you're trying to implement some of these tools. Now, as far as wills are concerned, right, it's the most basic estate planning tool available. It is essential because of the fact that it avoids what we spoke of earlier, interstate succession. It ensures that the assets are distributed as per your applicable personal law to avoid any kind of situation of probate being contentious. One should ensure that that will is drafted as per the valid requirements under the Indian Succession Act. Requirements are such that the person who is creating the will must be of sound mind and of course must be above the age of majority. The will should be executed without coercion, undue influence, or any kind of fraud. The will should clearly and specifically comprehensively address assets, whether they're immovable or movable properties. And the bequest should be made in a manner which is clear for the legatees to also take possession of those assets. One thing we've seen very often is that while a will may be robust and comprehensive and it covers all aspects as much as you think about it, very often in court, the point of contention becomes on what is not said in the will, leaving room for interpretation. That's why it's critical to sit with your advisors and really meticulously go through each paragraph, each line to understand when I die, how does this asset move on to my beneficiaries? Will there be any sort of impediment in terms of the transfer and transmission? What would they have to do? Should I prepare an inventory of my assets? What should I inform my executors in advance? Should I be informing them that they've taken on this role? Small things that they have to keep in mind. One thing that we always talk to our clients about is also trying and getting a medical certificate from your attending physician. Small things which basically will stand as evidence regarding your testamentary capacity to execute. We've seen enough and more cases where that has been challenged in court. So, clients have to be mindful of that. Of course, the execution should take place the requirement is in the presence of two witnesses. Our advice is always that they be independent, not necessarily beneficiaries under the will, though there is no law against that in India. It is clear that the biggest family disputes we've seen arise from these challenges to wills. So what are the other tools perhaps that are available? Because wills can be challenged at the time of probate. Now, probate is a procedure which is mandatory only in three locations. Interestingly, Mumbai, Chennai, and West Bengal. These were presidency towns in erstwhile, British India, and it's continued on ever since then. But to avoid situations where it can be challenged, it's important that families look at other means to dispose of their assets through a lifetime transfer. Otherwise, the probate risk continues. Now, essentially, the other tool available, of course, is through means of private trusts. Um, Private trusts have been quite popular in the last 2 decades. Old family businesses have had them for even longer, and they've really been able to stand a test of time if they've been drafted and structured in a manner which allows for flexibility, but really ring fences the assets. They've been very popular, and I hope we can speak a little more in detail about that in the next section.
Yeah. Sure. I mean, we know that, very well drafted will bring clarity on the asset distribution, and it may minimize the conflict among the family members. And also knowing that, will do have certain limitations, rightly, as you pointed out, that it may have a risk at the probate, or it may have a risk of ring fencing of the assets and possibility of dispute. So to bring this to our next important question, Sami, can you help us or share your thoughts of setting up a private trust? Can it offer more flexible alternatives in compared to will?
Yes, Megha. In my view, for effective succession planning for any family, one shall plan the forming of private family trust along with a will as a tool to facilitate seamless distribution of wealth or succession of wealth to the next generation in a predefined manner without much conflicts and disputes. And when it is a testamentary trust, which can save the cost of stamp duty and some other transactional cost if structure is designed in strategic manner. But all these things has to be done when a person is making or planning to make his will, and he should plan this strategic move along with the will to create a family trust.
Also, Samir, I see there are a lot of confusions, with regards to choosing which type of trust, whether it is revocable, irrevocable, discretionary, non-discretionary. Could you help us understand how one should decide between them, and what are the typical factors that influences this choices of types of trust?
Yeah, so this is something case to case basis one has to look into. But certain parameters, certain patterns has to be first established, like a family tree, age of the beneficiaries, their qualifications, their financial understanding, then complexity of the business associated with the settler or the wealth creator and risk associated with it, nature and location of the assets, whether they are Indian assets, they are located abroad, those assets also need to be seen into. And the beneficiary's location is also important. If the generation, the next generation to whom you want to give benefit, are they living in India or they are living in the countries where there is a risk of the estate duty or estate tax is there, or as their fate is dependent on the settlers' ups and downs. From beneficiaries' point of view, if trust is irrevocable and their shares are specific, they get the regular flow of income every periodic from the corpus, but they feel more protected if the funds are accumulated for meeting their specific requirements and milestones like education, traveling, medical, marriage needs, etc. And from the trustee's point of view, who acts in a fiduciary capacity, it will be discretion, it has to be his discretion to decide the flow of funds towards specific milestones without any fear. Then in that case he can play the role of the impartial judge. So these are my takes when we choose the structure based on the needs of the family and the requirement or the corpus what someone is planning for, and the beneficiaries, the type of beneficiaries. All these things play a interplay.
Yeah. So thanks, Amir. I understood that, based on the control and protection, we can determine the types of trust. I mean, which type of private trust that we want to do. And surely, trust clearly offers family with a strong tool for better succession planning from the point of view of asset protection and also ensuring that, settler wishes are carried out or executed based on what he had wished for. So it is also very crucial for us to understand, what are the legal aspects that one needs to take care while drafting the private trust deed.
Certainly.
And for this, Tanmay, I would like to understand your thoughts on the
Yeah.
legal aspects.
No, I think it's very important. I think it's critical the choice of trust that you make, right? I think some of the main things that we look at when we're trying to set up a private trust structure, what we hear from our clients is, if I transfer my assets into a trust, am I going to lose control over it? There's this fear of letting go of that asset, which is not necessarily the case, because you can still sort of, have a degree of control over it in an irrevocable structure as well as a trustee, right? So, because the trustee is essentially known as the legal owner of the asset, while the beneficial owners may be the named beneficiaries. So, when you make a settlement into a trust, if you make an irrevocable settlement, you do provide a great degree of protection against third-party creditors. Even this whole topic of this, this potential reintroduction of estate duty, which has been going on since 2013-14, very much in terms of even Parliament considering it for a while. It was there in 1985. It was abolished estate tax, but the broad contours of that, including what we see in foreign jurisdictions, is that private trusts do enjoy some degree of protection as long as they meet certain criteria, right? Like the settlement being irrevocable in nature. The fact that, once you make that kind of a settlement, it's no longer on your books. It forms part of the trust's books. And therefore, the risks that one may be associated with a will, let's say someone challenging your will after your demise, no longer exists because that asset is no longer part of your estate for the court to intervene in or any third party to make a claim on. So that is important. If we make a revocable trust, it gets that those kind of protections get a bit diluted. The same aspect regarding discretionary and determinate. Those two aspects are quite important from a beneficiary's point of view in terms of how that asset will be determined in their books. If we have a discretionary trust, it's harder to go after a particular beneficiary saying, you do have a determined interest in this trust. And therefore, we will try and attach any asset in this trust as part of proceedings. It can't be done because if your interest is discretionary, one cannot allocate corpus to you as a beneficiary. So that aspect where the trust is a irrevocable discretionary trust, even from a legal perspective, gives you the strongest degree of protection. So while clients consider the nature of trust they're setting up, there are benefits, pros and cons of all these permutation combinations. Some may actually be necessary depending on the jurisdiction you're trying to solve for. Like the US has certain laws which recognize protection to types of trusts in India, which may be revocable in nature. They call foreign grantor trusts. So it all depends case to case basis, as Samir said, to assess and analyze. I don't think, estate planning with trusts is never going to be a one size fits all approach. It always has to be bespoke. And that's where it's important that advisors and clients speak to each other on a very candid basis as to whether this solution is something best suited for that family.
Sure. So based on, I understood that, currently irrevocable and discretionary trust provides the highest level of protection. And also we understood the legal aspects of why to be taken care while drafting the trust. Let us now move forward. And Tanmay, can you help us to understand what are the other legal modes? That is the power of attorney, nomination, and how does it work? Whether it works simultaneously with will and trust?
Yeah, sure. Happy to address. I think, these are certain tools which are often overlooked and they're so critical. Especially, things like a power of attorney and nomination. A POA can be general or it can be specific. Not everyone decides to execute a POA because you need a degree of trust to be giving, an agent a power of attorney to conduct matters on your behalf. But it can be quite beneficial One thing is important to note that in certain circumstances, a POA can also become invalid. Very often, clients say that I do have a POA, but the person who's granted this POA is currently in a coma, or has lost mental capacity, or may have been even deceased. Can I still use that document? Unfortunately, that's not the case. In those situations, a POA becomes invalid. But a POA is a power where individuals who may not necessarily be able to be resident in India for some time or have certain businesses that they need to attend to, they can sort of issue this POA for specific transactions in favor of individuals. And it's very beneficial to have that in certain circumstances. Not necessarily that individual may be in a coma, they could be in an accident, but that could impact how business decisions are made. So a spouse, a trusted advisor could take those decisions on behalf for that interim period. Nomination is, something which has taken, even courts have now sort of recognizing the power of nominations, and regulators are standardizing how they recognize nominations. One thing it's important to note that a nominee is not necessarily the person who that asset will transfer to as per law. They are only the guardians, the trustee of that asset. They will still have to pass on that asset to the named legal heir, or in interstate succession, the class one legal heir. So they're basically an interim measure. What we advise clients to do is that you should sync up your legatees under your will along with your nomination, standardize them, sync them up so there is not enough, disputes amongst these two parties going forward in the future. Banks have also been directed by RBI to separate their role in all of this. Banks will only deal with the nominees, and it's up to the legatees then to coordinate with their nominees to get those assets in their hands. But it's a very effective tool that people should have this in place. With As far as family settlements, that's another tool which has been very useful and helpful in recent years. We've seen some of the largest family disputes being mediated and settled behind closed doors with the use of this tool. It's quite powerful. At the same time, family settlements also have a very favorable tax treatment to it in terms of how these assets are treated. If you look at the way the Godrej family dispute was sort of dealt with, there was a very robust way of how they managed and settled those assets. It's a 127-year-old legacy firm can manage that. I'm sure families out there should consider this as a very effective tool. There's been Supreme Court judgments in terms of the validity of family settlement agreements. Very often the question comes up that if you have a will and a family settlement agreement saying two different things, what would prevail? And I think courts have leaned on the fact that they will not go into the validity and credence of a family settlement agreement if done and executed validly. So individuals should recognize that if they have settled an asset in a family settlement agreement years ago, then they may not have the power then to deal with it under the will. So there is, thankfully, courts have been intervening more actively and giving more sort of juice and more credence to family settlement agreements, and families should now look at that as a very effective tool to mitigate family disputes before they become public and quite acrimonious. Advanced medical directives, I wouldn't go too much into detail on it today. It's basically still in its infancy stage because it requires quite a bit of infrastructure from the government's end for it to be effective. But for all purposes, it's essentially a document which would provide medical professionals the ability to essentially stop life-saving measures to be taken for that individual, or regarding any medical procedures to be performed. Very early days, we've seen a few been executed successfully in Goa and in a few other states, but Maharashtra, there's still time for that, for the forums to be built up, for the medical boards to be formed. So still, I think we are seeing clients looking to execute these, but in practice, I think there is still a few years away when we see the effectiveness of it.
Yeah. So thank you, Tanmay, for highlighting, how power of attorney becomes invalid upon death or a mental incapacity of any member, and how will still remains crucial even when the nominations are in place. Having said that, they both POA and will work as a interim measures for emergency that may arise in a family. And also, it is very clear that family settlement agreements offer a strong legal backing. And if it is drafted carefully, then it will ensure that they are binding and they are truly effective. Having said that, Samir, it reminds me that with SME IPO in place, and I've seen that many family owned businesses are going towards family constitutions. Does it mean that it is one type of a succession planning measure which is available?
This is very relevant question, Mega, in the given time. I believe somewhere between the ambition to grow and fear of losing the family unity, what lies is the real challenge. And succession planning at pre-IPO stage, and therefore the alignment of the financial ownership, operational ease, regulatory governance, and business succession to bridge leadership void plays a very vital role. And here let's understand from the promoter family who is going for IPO, for them, only the stakes are not now financial. Because if they are not united and if they have internal disputes or conflicts, that will impact on the stock market, it will erode their brand value and their reputation for which they were striving for so many years, and they have created it over the time. It can be messed in the some number of months or days. Sometime in past we have seen that there was some informal understanding were happening between the families, and the elders of the families were respected in that fashion. But now the time has changed, and because of the regulatory watertight norms, now the informal understanding does not stand the test of time. Therefore, emergence of the family constitution, such as a soft infrastructure, is very important. It's nothing else but it's the playbook between the family members governing the heart and soul of the business in the promoter driven business, and it's needed for the shared vision and values. And along with that, there is a need for a role for the family councils, advisory board, and family offices, where there is a professional approach to build the internal parliament. And one branch of family gets the voice, and external advisors help them in neutrality. So, this becomes a smooth communication across the generations to address their potential conflicts and disagreements without impacting the business at large. And this is the crux, because the communication is the key, and this becomes a platform for them to share their views. And all these things, whether it is family constitution, family councils, advisory board, all these things has to be SEBI compliant. When you are going for IPO, you need to understand the succession plan has to have the lock-in conditions as per the ICDR guidelines and regulations, and takeover code norms also need to be followed, so that you can be transparent and disclosed in compliance with the SEBI guidelines to avoid tripping with any regulatory wires. So, at the end of the day, it's not about just planning to get listed, it's about planning for a lasting legacy. That's what I can say.
Yeah, true, Samir. It is not just always to just planning about the IPO or listing. I think promoters or the owners need to even plan for their lasting legacy based on how companies, like other companies, like I've seen Dabur and others have done it.
Yes.
Now, moving on, Samir, I would like to
Sorry,
take this discussion one step further.
Mega, can I
Uh,
add one more point here, which is
sure, sure. Yeah,
it's very
sure.
interesting to note because, as mentioned by Samir, we're sort of moving from the world of being a private company to being in a listed space. Compliance goes through the roof. One important benefit, which is there as far as some of these pre-IPO structures are concerned, is the degree of flexibility you get. Because once you're listed, then you have to, promoters are not aware, but you suddenly fall into something called the December 2017 circular universe. What that circular has done for all purposes is that SEBI came out with that circular saying that, post listing, if you're going to be incorporating a trust structure, these are the guidelines which we find acceptable. And those guidelines are quite strict. They don't allow for multi layered trusts. They don't allow for beneficiaries which are private trusts. So sub trusts can't be implemented there. A private trust company can't serve as a trustee company. So all of this you could have done pre-IPO if you had given it some thought. If you have multiple branches which need their own private trusts, etc., you could have gone to SEBI at DRHP stage, told them that this is my legacy shareholding. These are the multiple trusts I have. I'm disclosing it in my DRHP. Please give your blessings. If you try to do this post listing, SEBI will very likely come back and say, sorry, please comply with the 2017 circular, which is very, I don't want layering of trusts. I don't want a layering of, beneficiaries. So very important point for some of the family businesses to know pre-IPO, there is degree of flexibility in how you structure your ownership, which will not be available to you post listing. So, important that they sort of speak to advisors and what's the benefit of doing this. Even if it's, a lead up to a DRHP, it's critical. We're doing this live on multiple matters, and lots of families are seeing the benefit of that now.
Yeah, thanks, Tanmay, for highlighting the SEBI circular, especially where it can be helpful for people who are planning for IPO and how that multi-layer trust structures of beneficiaries are not allowed. Yeah, it was truly insightful. Now, I would just like to take the discussion to next step, wherein Samir, I would like to ask the most asked question by most of our clients is, what are the tax implications under the estate planning? I mean, if the planning is done through will and what is through trust, can you highlight that?
Yeah, so when it is done through will, there is no tax implication. And the beneficiary, the legal heir who receives the asset, there will be no tax implication in their hand also. There will be no stamp duty. There will be no income tax, even if the will results into handing over the asset to the non-relative. There, the asset which they get as a part of the legacy through will, whenever that asset is sold, the cost of the deceased person will be considered for the capital gain purpose. So there is a one layer tax which is removed, and directly when the liquidity event comes, there will be a tax implication under a will. On the other hand, when it is a irrevocable trust, when there is a transfer of asset from the settler to the trust, which is irrevocable, there will be no tax implication. Provided the trust is created for the benefit of the relatives, then beneficiaries are the close relatives defined under Income Tax Act. The trust which generates income will be subject to the normal slab rate as applicable to individual. And but if trust is having a business, then the tax is the maximum rate applicable to individual, that is 30%. In both these cases, the slab rate will be applicable as applicable to the individual, and income distribution is not taxable for the beneficiaries, and capital gain has the same treatment as I discussed in the will, where the cost of the settler will be considered for capital gain purpose. And here also the more or less the treatment will be similar to what individual could have faced in his own cases.
Yeah, so thank you for highlighting the importance of tax consideration, where by comparing between the trust and will, particularly how will have almost nil tax impact, whereas the trust may have the tax impact which would be there for the individual currently.
Right. So the only thing is the concern area is the stamp duty aspect, which is applicable, which Tanmay rightly said in his conversation, which one has to address at the time of forming a irrevocable trust.
Yeah, I mean, it is clearly choosing between two, balancing between the tax cost that you will be paying it right now, vis-a-vis the asset protection and the future dispute, which may arise in will versus trust.
Yes.
Yeah,
Yes.
yeah. So with this, I would like to move to the next segment, which is of case study. And Samir, I would like to ask you a question. Given the trend that we are seeing currently, where parent continues to live in India, and while their children who are moved abroad for higher studies and eventually they settle there, we would like to understand, based on your experience, how should a family plan their trust primarily where assets are located in India? And what should be their approach for smooth succession planning?
Since your case is quite interesting from FEMA perspective, because here the one law which we have not spoken till now is the foreign exchange law, which is applicable in this case because the beneficiaries in this case are residing outside India. And FEMA triggers at 2 points. One at the time of creation of the trust, and second at the time of distribution of this wealth or income of this asset or corpus to the beneficiaries outside India. And here important is to know from the FEMA perspective. Here we have to address two laws. One is income tax and one is the FEMA as a top priority. First, I am dealing with the FEMA law. The situation needs to be addressed in such a fashion that when there is a trust which got created, and if that trust is created for the beneficiaries outside India, that means this is a gift to the non-resident, and therefore this requires the RBI permission. Now there are some relaxation by RBI here when it is the transfer of asset or the gift is to the non-resident individual NRI or OCI holder. And other than NRI and OCI holder, the the approval route has to be followed when you are doing such kind of structuring. Now, from the taxation point of view, is also important since these are the close relatives falling under the definition of relative under income tax. Whatever asset is going to them, the whatever income is going to them should not be taxable, but we need to see the law of the country in which these beneficiaries are residing. Whenever the distribution is happening from the trust to the beneficiary, we need to follow the LRS guidelines if it is going out of the country directly to the beneficiary account, or if it is happening to the beneficiary's account in India, then the money should be transferred to the NRO account. And from NRO, the beneficiary can take up this money outside India based on the NRO to NRE guidelines, which is currently $1 million. So these are the parameter one has to look into when we are structuring the overseas, structuring the trust for the overseas beneficiaries.
Okay. Yeah, thanks for highlighting, how one need to look into the residential status of the beneficiary, the RBI and the OCI guidelines. We need to also look into the FEMA and the LRS routes that is going to be there in this trust structure. Also, how important it is for an individual to check with the tax consultant because he will look into the current tax situation in India, and also will have to look into the country in which the beneficiary is residing.
Right.
Yeah, that was true. Moving on, we move to the next question, next case study. Tanmay, I would like to understand that how can a family business with multiple branches manage ownership, control, and succession effectively while maintaining the alignment across the family? And what are the key considerations that they should keep in mind while doing the same?
So, this is it's a sort of case study that we see on a live basis very often, particularly in India, where there are businesses which have been built over multiple generations. Now, one generation to the next, there is going to be a divergence in terms of goals, aspirations, risk appetite. At the end of the day, though, numbers will matter, which will essentially, sort of cause some difficult conversations to take place. There is a way to solve for this, to align family interests, but also ensure that individual aspirations are not curtailed. This can be done through, private trust structures, which basically become the pooling vehicle, the control vehicle, a sort of a master trust with sub-trust structures for different branches. Now, one thing is there that, at the end of the day, while we are seeing the shift from just joint family ownership to a nuclear family. There are going to be businesses where ownership is a little more fragmented amongst not just one family, where there'll be a nuclear family, but there'll also be cousin consortiums which are operating these businesses. Each one has differing value sets and principles, goals and aspirations. For that purpose, we are seeing that the most important framework which could work for them very well is to have some degree of governance. This could be through a central governance board, like a family business board, where all family members who are perhaps decision makers, they sit on that and they can really discuss in terms of the direction of that business. In terms of ownership interests, it could be the case that the ownership of the hold co, the operating co, is in one master trust, of which the beneficiaries are sub trusts. Or it could be that the ownership is separated into each branch trusts, but there's a shareholders agreement amongst them in terms of how decision making should take place. So there needs to, all of this, like Samir had pointed out earlier, the days of the past was a lot of informal understanding. That has led to dispute situations. Here, families want clarity, cohesion, and while they may be on their own separate paths, as far as the operating company is concerned, there is a structure in terms of how decision making is made. So the importance of having a document such as a family constitution, which sort of binds them together on principles, on values, helps create governance. Decision making can be achieved through having a robust private trust structure, which is then linked up perhaps with a robust shareholders agreement amongst them. They could also ensure that there is, if there is has to be decision making, a forum such as a family business board, it is key decision makers who are on that board. Separately, for family related matters, a family council can be formed. There, the membership can be much broader. It could include people who are not necessarily active in the business decisions, but want to sort of contribute to other aspects of the family, which could be philanthropy, which could be other new age businesses. It's also a good opportunity for the next generation to be groomed. One big gap which happens is handing over the baton to the next generation in terms of leadership succession. There's not enough exposure. How does the business function? One can ease them in to that through these various mechanisms, so as to integrate them, to make them understand what is the business, how is it growing, where the direction is, what is the legacy that we're trying to build, rather than people sort of just holding this in the individual name. There's constant insecurity. The patriarch is loved and cherished only to the point when he hands over the assets. Post that, he becomes irrelevant. That is, those are not the situations we want to see today. I think each family member plays a very important role. There are a lot of chairmen who are there today who've built the business, but they serve in an emeritus role where they're sort of looking at the legacy of the business, at CSR activities. There are we're seeing such a encouraging change where women are coming to the fold and they're becoming key decision makers, which is important. And I think what's critical now is that these families recognize that there's been a generational shift of how India is growing, how businesses are growing, and how investors are also looking at this business. Mark my words, I think you will see premium from external investors where they see that there is governance, where they just see that there is clarity in succession. Those businesses will receive premium in terms of investment from foreign external investors. And that's why it's important that when the business is growing, it's important to give it structure then. It's the right time to have the most difficult conversation is when everything is going right.
Yeah. Thank you, Tanmay. It was truly insightful, and I do understand the importance of governance in the growing business and how India is moving ahead. Now, to just conclude a wrap up, I would just like to take one message that stands out when it comes to succession planning. It's always better to start early, and I think with COVID, we all have got the answer that age should not be the number or deciding factor. What matter is the timely action and clear thought. It is also important for us to approach the estate planning very strategically, legally, and it is better to have an open conversation with the key family members who would be their beneficiaries in order to avoid the misunderstandings later. Also, I think will can serve as a strong first step, and over the period of time, one can evolve the will and maybe get into a structure solutions like trust. And I would like to say, until any succession planning is put into place, having at least a proper nomination in places will remain very critical to ensure that assets are passed smoothly to the intended beneficiaries. Yeah, thank you all for joining us for the today's session. I hope today's discussion has helped you to think about succession planning and not just an option, but it should be your priority. Now the floor is open to Q&A. I will just look into the questions which I have come across.
Yeah, some very interesting questions, some of them being quite billable in nature. So happy to sort of go through them.
Okay.
Yeah.
The first question which has come is, can HUF be used as a succession planning tool? Samir, would you like to take that?
Uh, HUF actually is not for succession planning tool. Generally, it is misconcepted by many people that it was created in context of the exempt income tax it was enjoying for the slab up to 2,50,000. Earlier it was 50,000 and that it went to 3 lakh also. So because of that, people started creating HUF file. Generally, HUF is for the ancestral property which comes to you from the legacy. And if there is some forefathers property which comes to you, the third generation, second generation, third generation, there becomes a HUF property for you, for which you don't have the sole authority to deal with it without the consent of the other family members and for the benefit of the other family members. So it is never your personal property. So this answers, I think, the question.
Okay. The next question is like, banks are insisting for probate of will. If the probate of will is not there, they provide them into a settling of the claim to nominee instead of the executor. Tanmay, would you like to answer?
Yeah, sure. And just on that point on HUFs, I'm actually not a fan of them at all. I think it's the worst succession planning tool out there. I'll be very candid about it because as far as your stake interest in an HUF, it's constantly dynamic on the birth and death of a member, family member. And like Samir said, it's not necessarily something that any asset that an HUF owns, you can't write that down in your will. So it is a tax saving measure, but if we're looking at a larger estate, I would always advise clients not to contribute more of those personal assets into an HUF because it is not going to be an effective succession tool at all. As far as the second question is concerned regarding banks, I think the way their sort of internal policies work, it's a bit mechanical, not recognizing what the legal position regarding probate in this country is. As I mentioned earlier, mandatory probate is only applicable in Mumbai, Chennai, and West Bengal. Now, banks cannot actually insist if you don't own any, if your will is not subject to mandatory probate. When does it get subjected to that? If the deceased had owned immovable property in any of these three locations, or they had executed their will in those locations. If that is the case, then your will is subject to mandatory probate. Now, as far as banks are concerned, frankly speaking, RBI has been very clear on this. They've issued circulars saying that the bank does not have to deal with the executors or the legatees of a individual's estate. Their relationship, which is contractual in nature, is limited to the nominee. They will allow the nominee to deal with that particular asset. Now it's up to the legal heirs and the executor to deal with that nominee. Now, if the legal, that's why we always advise they should be the same person. Now, if the legal heir and the nominee is the same person, there is really no hassle. In this situation, banks, where I think the question is that you've not provided me with a probate, etc. Banks don't need to get into that question. Like I mentioned, their role has now been very limited by the RBI in terms of you only deal with the nominee. There is no requirement for that demand for a probate order. Sometimes we see even housing societies ask for it, which is valid in that case because for them to be able to when it comes to immovable property, there has to be a probate so that mutation takes place on the registrar's books, etc. Society can recognize it. But with banks, this is really an unnecessary conversation. And we've written to various banks, sort of educating them on this, on the law, which is currently there.
Yeah. Okay. I take up the next question, wherein there are two questions altogether. The question is, in case of a divorced mother wanting to plan succession with only son as a succession, and the mother has assigned all the assets through nominee, can asset be transferred through nomination only, or a will or POA is necessary? And the second question is, if this, in case of a step brother to the succession, does the step brother have any claim on the mother's estate? The stepson is from the another, father's another wife. Um, Tanmay, would you answer this?
See, I think as far as stepchildren are concerned, as far as the law is concerned, if they're not legally adopted, they don't have an automatic sort of claim on estate. Um, so is the question regarding only how can I pass on that asset to the stepson?
Mm, The
I
question
think
is,
the question is what I understand here is that
Question of
divorced
claim
mother
is,
has some estate
hmm,
and she wants to pass on to the son, her natural son, as a
yeah,
successor. I think that is where, and I think you covered well in the first, second question.
hmm.
The next question is about if the father has another marriage and out of that there is a another son, which is a step brother for the current successor. Is he also entitled to any benefit out of the divorced mother, the first wife uh, property or estate?
So, see, the position as far as the Hindu Succession Act is concerned, that it's sort of a stepson is not considered a son for the purpose of interstate succession. If you have written a valid will, where you may have written out your stepson from that will, the stepson can't make a claim that he has an interest in it. I think it's very clear that you've executed a valid will. If you've excluded an individual, that does not necessarily then give that right, especially a stepson, to make a claim on that estate. So it's important to put the will in place. If there's a situation of interstate succession where there is no will, the claim of a stepson would not be necessarily recognized there. We did recently see a case with the ITAT recognizing stepchildren as relatives, but that's different.
yes.
I think
Yeah.
that's not necessarily, you can't equate the same as being someone who is going to be a claimant such as the class one legal heir, if they've not been if they've not been legally adopted.
Yeah. Okay. I think that answers one more question.
But
And
don't you think, Tanmay, just to argue on that point, I take judgment, don't you think it should the situation should have been from the father's property if the both the sons are claiming the rights and they are getting anything, they are considered as a relative. But here the case is different,
Yeah.
where divorced mother has one son and the father has married other woman and she also has one son. And that stepson, can they have claim on the first wife property or estate? This is the question. So I think your point is very well covered, but I think that tribunal judgment has to be seen from the different perspective, from the taxation point of view.
It's a very broad reading of it. I
Yeah.
think it's encouraging in that sense, because dynamics are changing in terms of how India also views families, right?
Yes.
So perhaps I think it's a move in the right direction. It will take some time to digest, even for lower ranking officers to take that in, because we have seen situations where the family dynamic has become different than what a traditional family used to be. So it with times, I think you will see that such kind of transfers should have legitimacy. When it comes to succession, I mean, the Indian Succession Act, Hindu Succession Act, quite dated. They also need a fresh look. We're seeing all those conversations happen with the UCC, but that's a controversial conversation for another day, then I guess.
Right.
mm, yeah, Sami, the next question is, what is the MMR rate, whether 30,
MMR rate is
39%?
30%. Maximum marginal rate is the tax, that is 30% plus surcharge. And that surcharge is depending upon the slab of the income applicable to individual. So it is not blanket 39%. It is based on tax plus surcharge. And there is recent tribunal ruling on this. I think just recently passed 1 month back.
Hmm. Yeah. And whether the deductions which are received by an individual will also be received by the trust.
Um, Today, very few deductions are available to individual, but the trust, if they are allowed to claim such kind of deductions, they can be like donation. They can claim the benefit of donation, but they cannot claim the deduction on account of the investment in PPF or life insurance or ATC benefits under old regime.
Uh, Tanvi, the next question is recently in the will of Ratan Tata, there was a news regarding a non-context clause in
Correct.
the will. The beneficiaries couldn't challenge the will. Does this protect the will?
So, Mr. Tata was someone who sort of took his time to consistently revise his will depending on circumstances. So, great practice. In terms of the structure of the will, this is something which we're seeing is quite common. There's a Latin term for it as well. It's called the in terrorem clause, in terror, basically, to dissuade claimants, third parties to sort of make that claim. See, while we understand the intent of the clause, as far as Indian law is concerned, it does not necessarily prevent you from making a claim. Courts would still entertain, a contest to it if there is based on merits, of course, of the claim itself. So what it does is it does act as to have some sort of persuasive value to, for beneficiaries under the will, if they feel they've not received what they should have received, to perhaps not contest the will, cause, disruption in the family. It's sort of a dissuasive kind of tool, but I would not sort of rely on it that this completely takes away the right of legal heir to make a claim. I think that right is inherently sort of available to him to do that. So we do see it in wills regularly, but I wouldn't lay absolute reliance on that.
True, I've also seen a lot of debate around it. Samir, is a trust eligible for LRS?
See, as such, trust is not recognized entity under the FEMA law, so it is the all principles applicable to individual. So, and it is meant for the family only, and beneficiaries are all relatives. So, trust also undergo the requirement of the LRS.
The next question is, can beneficiaries also serve a trust, can serve as a trustee of the trust? And what would be your advice in such scenario? What would you constitute what would be a trust be in an ideal structure? What would constitute?
Uh, Tanmay, you want to
Yeah,
take
happy
it?
to take that up. So, of course, beneficiaries can serve as trustees of a trust. It depends on the type of trust, really, right? When we're looking at what we're trying to address, if we have a trust which is essentially a determinate trust, where the trustees also has the power to make that distribution, you will basically end up in a situation where you will dilute ring fencing of that trust, right? Now, if it's a discretionary trust, irrespective of whether he is a trustee, a sole trustee, or with multiple other trustees, it's not necessary that you can make a claim that you are only in control. You can make this distribution to yourself. It's because it's predetermined. That's not the case. So it will depend on what are we trying to address. Is it the issue of ring fencing? It will not be great for a beneficiary to serve as a trustee if he also has a predetermined interest, because that would dilute ring fencing. It's perfectly fine. What we always advise our clients not to do, of course, is to serve in all three capacities, because then, very likely
Hmm.
the tax authorities are going to look at this as a sham trust, particularly if you are the only beneficiary of that trust. If you've
Yes.
settled it, you are the trustee, you're the only beneficiary, there is enough jurisprudence to say that, this is a complete sham trust. This trust is, that's as if the transfer never took place. What we sort of also try and tell clients is that perhaps don't be a settler and the sole beneficiary, because there again, it's as if that asset has never really left your hands for all purposes. So trustee and beneficiary is okay. One will just have to take care of in what circumstance are you trying to address a ring fencing issue. Then perhaps in a determinate trust, that's not ideal.
Yeah, so
Yeah.
another question, Tanmay, is that can you share more insight on what are the probate
Sure.
risk?
So the probate, the way, like I mentioned in these mandatory probate jurisdictions, you have to go through the process where the executor will make a application to court, seeking probate for the will. Now, during that time, the court will essentially notify the legal heirs of the deceased. Also give a 2 week, essentially it's a 2 week notice that anyone who has a claim against the estate, or if you have any sort of if you have another will in place, please come forward. Now, that could basically be a spanner in the works, right? Even we've seen that, as far as non-contentious probate proceedings are concerned, the Bombay High Court has taken anywhere between 9 to 12 months to deal with it, not because of any other reason, but there's such a big backlog. Being a mandatory probate jurisdiction, the number of cases which have just come up, even for the smallest of properties, has created this backlog. So one big risk is, again, from a timeline perspective, even if there is no one contesting that will, you still have to wait your turn. The other risk, of course, is that tomorrow, if there is a challenge, that probate will turn into a civil suit based on the merits of that challenge, right? The minute it turns to a civil suit, best of luck. You're looking at anywhere between 5 to 10 years to try and, in very high legal fees. Not that I'm complaining, but that's the situation you look at. So avoiding probate is certainly a reason why lots of clients are looking at lifetime transfers through private trusts.
Hmm. Yeah. Samir, can you share, can the shares of HUF be attached for any liability?
If HUF has given any kind of guarantee, and if that guarantee triggers, then definitely yes, it can be subject to the attachment. But there are various challenges, because before giving guarantee, the the person who takes the guarantee has to, or the lender has to, look into the parameter that whether the HUF has any minor or not, because the minor rights cannot be attached. But many times this is missed out, and practically if these shares are given as a guarantee, there can be a attachment.
Next question for you, Tanmay, is that your thoughts on relevance of family constitution.
Yeah, so I think it's important, but one must recognize that it may not necessarily be a legally enforceable document based on how it is structured, right? Family constitutions are not necessarily agreements where there is consideration, where on account of the fact that this may just be an understanding between family members, which is separate from a family settlement agreement, where courts have recognized that for the natural love and goodwill that to mitigate disputes, that is consideration enough. But in a family settlement agreement, uh, there are individuals who sign up to it, but does it meet the valid essential elements of a contract becomes the big question mark. There have been solves and workarounds around that, essentially that at the signing of a family settlement agreement, there have been monetary amounts transferred between family members to get there, basically to show that you've taken some benefit from that family settlement agreement, and therefore you can't now resign and claim that it's not a valid contract per se. So it will depend on the structure of how that family constitution is made. But I think more than from a legal enforceability perspective, the kind of impact it can have on decision making, on family relationships, you can link them up also to other arrangements within the family, that if there is a if there is a non-compliance with the principles set out in the family constitution, there will be implications based as your ownership in other holding vehicles. So it will depend on the construct, but by itself, it's there is a little bit of challenge in terms of can it be legally enforceable if there is no consideration, if there's no benefits derived from any party to any party.
Yeah, I think
That's not the reason why families enter into it. I just have to make sure that it's not just about it's more about to ensure that legacy is preserved. So it serves a very different purpose, and that's why families consider it as important.
mm, I think with this, I think I'll take up only last question. I think we already shoot up the time. Probate is required in 3 cities. If person staying in another city make a will at Ahmedabad and having an asset in Mumbai, does it require probate?
Yeah, if they have an immovable asset, if they have ownership interest in an immovable asset in Mumbai, Chennai, West Bengal, best of luck. And this is so strange. I've actually petitioned the Rajya Sabha against this issue, and they sort of decide. I hope they take it up because this needs to change in this country. It's been 100 years. We're still stuck with a British era kind of problem,
Yes.
where an individual you can have 100 properties in Delhi and Bangalore, but you don't have mandatory probate there. But a person owning a 1 BHK in Bombay is suddenly his estate is subject to probate in Bombay High Court. So it's a real problem. It costs money to get that probate, time, effort to deal with that estate. So to answer this particular question, yes, if that individual had a immovable asset, he maybe even, like he said, he made the will in Ahmedabad, but
Hmm.
since that removable asset is in Mumbai,
Mumbai.
it will still be a probate, mandatory probate situation.
So to add to Tanmay what he said, I think even if you have one property either on is these three cities, and you have to make your will probated in the court, and all the assets will be public document in that case.
Yeah.
Yeah,
So
Tanmay.
I've had lots of clients actually who are not aware of this. They've gone
Yeah.
ahead and sold these properties. They say, I don't want this to be something which is a matter of the court to take up. And of course, they move in a situation where the Mumbai property was just an investment. They don't even reside there, so they're okay to offload that asset. But this is the risk which comes with jurisdiction like Mumbai.
Yeah. Thank you all. It was actually a very interactive session. For any queries, please reach out to the INCOP and Trilegal website. And also, please look and visit our Inflix for any future updates on webinar. Yeah. Thank you all.
Thank you, everyone.
Thank you.
Thank
Thank you,
you.
Megha. Thank you, Samir.